Today's class centers on one of the most vexing issues in AI and law. That's the intersection of the First Amendment and free speech values in AI. And thankfully, we have one of the brightest minds in this space here back on scaling laws to talk about that intersection. Peter, thank you so much for joining. I'm very excited to analyze your paper. AI outputs are not protected speech, which was published by the Washington University Law Review last year, and something that you've paid close attention to ever since. So thanks so much for taking the time.
Thank you for having me, Kevin. Always a pleasure.
Well, Peter, let's just get back to basics. As you know, here on Scaling Laws, when we're doing our Academy series, we first start with the fundamentals of the law. Then we move into how that kind of collides with AI before we end with an analysis of what we can keep an eye on going forward. So when we're talking about the First Amendment, let's just specify from the outset, what is speech that's protected by the First Amendment? Easy question, go.
Yeah, you started with the hard part, and maybe we can get it out of the way and get to the easy part. No, we're not going to be able to figure out exactly which speech sort of ex ante. The First Amendment has all kinds of different doctrines that are triggered by all kinds of different things that impose then a bunch of different kinds of scrutiny on laws that regulate those things. So, if you read a basic sort of Hornbook summary of the First Amendment, the Hornbook will sort of will cut the world into sort of, I guess, maybe three parts. One part is laws that don't affect speech at all. A second part is laws that do affect speech, but in a way that's not based on the content of that speech. And then the third part is laws that are, we say sometimes, content-based. And in each of those parts of the world, we apply sort of ever-increasing levels of constitutional scrutiny to those different kinds of laws. Now, I just want to say at the beginning, I don't think that tripartite division is right. I think it's at best a kind of rough approximation of what the First Amendment's doing. And that's partially because we have all these other First Amendment doctrines that don't fall into that division. So, for example, if the government writes something that looks like a defamation law, a law that punishes you for telling lies about people, we just have a totally different framework for evaluating that. It's a framework from a case called New York Times versus Sullivan, and we ask about whether the false speech was made with actual malice, and that has a special definition, and there are a whole bunch of other rules like that. So that simple picture of the First Amendment isn't right exactly, but I think it does capture something that is more or less true, which is the more it looks like what the government is doing is looking at some speech, some expression of an idea, something that's in a person's head and they're trying to communicate to somebody else, and deciding whether or not that person is allowed to make that speech based on like the idea that the person wants to convey, the more the First Amendment is going to be very suspicious of that government action.
And one thing we can probably say that everyone agrees on, even though, of course, there's an exception here that would involve a whole rabbit hole exploration, but we're focused here explicitly only on government infringement, government regulation of speech, not private actors, right?
Yep, we're doing constitutional law here, which in most cases, although not all, the 13th Amendment is a notable exception. But in most cases, that means that the constitutional protections are going to arise only when it's the government doing something to you.
And when we think about some of those laws that may find themselves in that most rigorous bucket of analysis in terms of strict scrutiny, what's a good example of a regulation that you can either throw out a friendly hypothetical, or where have we seen strict scrutiny apply with respect to a regulation impacting speech?
Yeah. So the classic example would just be there's some ideology that whoever's running the government doesn't happen to like, and they make the advocacy or teaching that ideology illegal. So for a long time, the First Amendment was basically the law of throwing communists in jail. There were all kinds of laws that prohibited you from in various ways advocating the tenets of global communism. There's everything from federal laws all the way down to sort of state syndicalism laws. That in various ways, if you said things like, I don't know, capitalism contains within itself the seeds of its own destruction. The global capitalist order will eventually be overthrown. You'd be sort of put in jail for that. And that's just a classic sort of ideology targeting government action. Insofar as the law says you're not allowed to advocate ideas that would imply the end of the American sort of constitutional order, that we're going to put you in jail. Okay, classic, straightforward regulation of speech based on its ideology. Another example from a real case. It seems pretty straightforward. There is a case called Johnson versus Texas, I believe. Is that the right caption for the flag burning case?
I think so. I think you're right.
Yeah, where our you and I are now both residents of the great state of Texas, and
Yeah.
the great state of Texas wrote a law that forbade the burning of the American flag. The Supreme Court had to decide whether that law was constitutional under the First Amendment. And one thing they asked is, well, what's going on here? What's the purpose of this law? And the state of Texas said, well, the purpose of this law is to preserve the American flag as a symbol of national unity. And so when you think about what does that mean? It means, well, if you're using the flag to symbolize, to express something other than national unity, maybe dissatisfaction with the United States government, well, that's going to be what's forbidden. That's why this burning is forbidden, because it communicates something other than the flag as a symbol of national unity. Supreme Court basically strikes that law down without even needing to do the full strict scrutiny analysis, because it's so obviously a law, at least in that instance, designed to suppress a particular idea.
And when we think about why we have this particularly protective structure around this ideology-based speech, or really expressive speech, is it correct to say that this is sort of implicating some core free speech values here, where we're thinking about, of the sort of speech we want to make sure that is able to get out there, is able to be part of the public discourse? It's this really expressive or creative personal speech that we want to make sure there's room for. Is that a fair analysis?
Well, that's the kind of thing law professors say a fair amount. This idea that the First Amendment is about protecting a set of values, or maybe a couple sets of values. I think there are maybe three classic buckets. One is that the First Amendment is about democratic self-governance. It's about figuring out how we should rule ourselves, what the laws should be. And if that's the set of values you're serving, then speech that's about politics and about governance might be the kind of speech that gets the most protection. Another theory that goes back to at least John Stuart Mill is the idea that speech is about finding out what's true, and the best way to find out what's true is to have this kind of marketplace of ideas, this environment in which 1,000 flowers can bloom, and then the ideas that prove most useful or most amenable to verification will win out, and that if you're suppressing particular ideas, then you'll just lose out on the potential true ones. And then there's a kind of set of theories where speech is more about the individual citizen and their ability to kind of develop as humans, to self-actualize, to engage in artistic and creative activity. And so under each of those theories, you might just have different kinds of speech you think is most important, that you sort of think that the Constitution should protect more. But in general, the First Amendment doesn't distinguish. At least it doesn't distinguish very strongly between different kinds of expression. We sometimes see in opinions Supreme Court gesturing at things like political speech being among the most valuable, But then sometimes we allow certain kinds of political speech to be forbidden or burdened in various ways. I think the most consistent regularity across speech doctrine is not around the topic or kind of speech that's getting protection, and more around the question of whether the law is like directly targeting some communication, some expression in the first instance.
And so, just to complete our run through of the three core buckets, if you could briefly explain intermediate scrutiny and rational review or rational basis, just to cross those off in terms of making sure we've got
Yeah.
a complete map of what sort of speech or lack thereof may fall into each bucket.
Yeah. Do you want me to do strict scrutiny too, or do you want me to describe the tests or describe what kinds of things get the tests?
Uh, let's describe what gets the test, and then we'll make
Okay.
sure we're zoomed in entirely on strict
Great.
scrutiny. Yeah.
So look, in that classic sort of tripartite model of the world of the First Amendment, laws that we say are content based, with classic examples being like advocacy of communism, advocacy of fascism, advocacy of whatever is forbidden. Okay, strict scrutiny, that's the strongest kind of constitutional review. At the other end of the spectrum is rational basis review, which we actually say every law is subject to, irrespective of whether it's about speech. Like a law must have some conceivable rational basis. I think this comes from the due process clauses of the Constitution. I think.
I think you're right. And I think we go so far as to even say we don't even need Congress to tell us what it is. We can just guess at what they were thinking. And so long as we can find some excuse, we'll run with that.
Yeah, so it's super minimal. It doesn't mean that, the Solicitor General of Texas or the United States has to show up and give the actual reasons that Congress had in mind when passing a law, and show that they're super good reasons. It just has to be that you can kind of read the law and infer like some non-arbitrary, non-irrational goal underlying it. So it's super minimal. Basically, every law passes it. Although there are examples of appellate courts striking down laws for lack of rational basis. I think maybe the Seventh Circuit, or maybe it's concurrence. I think there's a Dick Posner opinion saying that laws forbidding same-sex marriage lacked a rational basis. But I
Well,
could be misremembering.
homework
But it's very
assigned to
rare.
all the listeners to go
Yeah.
check that out and correct or confirm Professor Salib here.
And in the middle, we have this thing called intermediate scrutiny. And intermediate scrutiny classically gets triggered where laws affect speech, but they're not like regulating the speech directly. They're regulating some kind of, in the paper I say some sort of useful tool or venue for speaking. So the two classic examples are what we call time, place, and manner restrictions. So in most places, you can't, for example, have a protest on the highway. Protests are often very important political speech, but you're not allowed to get a bunch of people in the middle of I-10 to protest whatever they're dissatisfied about. And we say that, well, that law clearly affects speech. Like, it might be super effective to protest on I-10 because everybody's going to know that you're doing it.
Please
So
don't do
clearly
it on
affect-
I-35 either. For all my Austin area residents, we have enough traffic. I don't have to be here for that long to know that the complaints about I-35 traffic are real. So let's just not do that. But yes, okay, good to know. No protesting on highways.
Yeah, no protesting on highways. You'll get arrested. And it's not that you don't have a First Amendment claim there. It's just that the law is reviewed under intermediate scrutiny. We think, look, this law is not actually targeting the speech directly at all. It's not about the content of what you're saying in your protest. It's about there being like some real non-speech related costs of having a bunch of people in the middle of I-10. And we apply this kind of scrutiny also what we call incidental burdens on speech. So, for example, you're not allowed to light your house on fire, even if you would really like to express that, I don't know, the developer that made it is a flaming pile of garbage. Again, because we think that there are real costs of that are not about speech, and the law, in fact, in that case, doesn't even reference speech. So intermediate scrutiny applies to a lot of stuff. It might be that like most laws described correctly affect speech in some way. It's just that most of them are not written with the purpose or like the obvious effect of regulating the ideas that you can express. Usually there's some other place you can go. If not the highway, the city park is somewhere you can protest. And because there's these other places where you're free to express exactly the ideas you want to, we don't think these are as pernicious from a First Amendment perspective as the laws of strict scrutiny.
Yeah, and for all those listeners looking for a little bit further reading, because of course we wouldn't be good law professors if we didn't endlessly assign reading, you can go check out the FSC versus Paxton decision that came down this summer, looking at an age verification law that was passed by the Texas state legislature with respect to access to obscene content, and there the Supreme Court applied intermediate review and upheld the law. So if you want to dive further into that bucket, feel free to do so. But Peter, now let's move on to the biggie, just to clarify what exactly strict scrutiny means. And now I want to slightly move into the land of the nexus with AI policy. If you could also flag why it's so important to understand the bounds of strict scrutiny with respect to AI regulation.
Yeah, so strict scrutiny, and then a whole bunch of other kind of specialized First Amendment tests that apply when the government is like pretty clearly regulating speech directly. So strict scrutiny applies when the law is sort of like written on the basis of content. Then we also have some more like specific tests for specific contexts. So if you write a law forbidding a certain kind of speech because you think it's likely to cause mayhem, right? It's likely to cause people to go commit crimes or try to overthrow the government. We use the test from a case called Brandenburg versus Ohio. I had mentioned before, if you write a law that forbids you saying certain stuff on the basis that stuff is false, we'll often apply a standard from a case called Sullivan, New York Times versus Sullivan, which is about defamation. But all of these tests that arise when the law is about regulating the speech itself rather than some tool or venue for speech, they're very demanding. And the classic strict scrutiny test requires that the law have a compelling government interest. So the thing the government's trying to accomplish has to be really important. The law has to be, we say, narrowly tailored to that interest, which I think we kind of mean doesn't forbid a lot of stuff that is sort of irrelevant to the purpose of the law. And maybe in the other direction too, it does forbid most of the stuff that is relevant to the purpose. And then sometimes we also say that strict scrutiny requires that the law be using the least restrictive means of achieving the law's purpose. So if there are two ways you could kind of do the same thing, one of which restricts more speech, then the government has to choose the less restrictive one. These other tests I described, Brandenburg, Sullivan, they're all very demanding. The law will like be almost presumptively invalid if any of these tests are triggered. So it's a big deal when one of these tests gets applied to a restriction on speech. And why does that matter for AI policy? Well, because AI is broadly construed a category of stuff that it's a category of software that produces stuff that looks like speech, right? And there's many different kinds of AI. The paper will probably discuss a little more. that I wrote is mostly about regulations of large language models, which produce stuff that really looks like speech, right? It's like sentences, it's paragraphs, it's text with ideas in it, it's questions and answers. And so, insofar as law, insofar as the law said, look, you can't release an AI system, an LLM that says, I don't know, pick your thing that you're worried AI might say, from disparaging stuff about certain racial groups to, of course, I'd be very happy to help you make a bioweapon. Step one, dot dot dot. Right? These are things that we worry. LLMs and their descendants will be totally able to say, and in some contexts it'll be really bad if we let them. And so, insofar as laws are forbidding the production of those words that come off of language models, and insofar as they may seem content based, right? You shall not allow your LLM to produce instructions for the production of a bomb or a bioweapon, or to teach you about cyber attacks or this kind of thing. Well, that has some flavor of a content-based restriction, and you might worry that those laws will be subject to strict scrutiny. And if you, like I, think that AIs will become, have already become, and will continue to become more capable at either doing things on their own, like say cyber attacks, or at making humans who want to do bad stuff but are currently bottlenecked by their lack of knowledge in say chemistry, if they want to make a chemical weapon, will make the bad human actors much more able to do that stuff. It seems totally reasonable to want to think from a regulatory perspective about what AIs are allowed to say.
And pointing out pointing out that you made a really good point here, which is we need to be really specific about the kind of AI that's being subject to a regulation here. And you and I and just about every other law professor in the world has pointed out that it's really hard to define AI. Depending on who you ask, they'll walk you through a history of how AI was defined in 1950 and then the changes that's occurred in each decade, and they'll remind you of all that history. But I think even just looking at a snapshot of the models available today, you can go use Meta's segment anything model, right? And be able to use AI to identify where a liver is in a cow. Right? That's a form of AI, and that's great. And I'm glad that someone has access to that tool. But you raised the point that if we don't have the sort of specificity as to what falls into that AI bucket when we are trying to regulate certain aspects, we may risk bringing in certain AI tools that weren't intended. And yet, this is just a really hard definitional challenge. And so, moving into the fact that that's one issue, and now putting that to aside and looking at the fact that we still don't know for certainty whether AI outputs from LLMs qualify as speech, we're dealing with a whole can of worms just on those two separate inquiries themselves. And so I want to focus on this question of whether AI outputs qualify as speech. And if you could kind of paint us a description of the spectrum of different views that exist among legal scholars about why and how AI outputs either do qualify as speech or do not. What's that look like?
Yeah. So I want to just, first of all, just agree with you. There's like a lot of kinds of AI, and like who knows? Is some of it AI? Is some of it just statistics? And like is machine learning the same thing as AI? Whatever. Like we can hold all those questions aside, um, and emphasize that the First Amendment analysis will change a lot depending on what kind of thing you're talking about. And it's also going to change a lot depending on what the law does with each of those things, right? So for me, I'll just give you like two axes to, like a 2x2 matrix of examples to pump this intuition. So on the one hand, we have like LLMs, right? They're like these big deep learning models that you put natural language in, and they mostly put natural language out. Um, and a different kind of AI, if you want to call it that, is like the social media or like feed rank algorithm
Yeah,
that like
classic
Twitter uses or
recommendation
Facebook.
algorithm.
Yeah, that's machine learning. It's doing something very different. It's taking a bunch of other kinds of input, like I don't know how long the eyeballs stay on each kind of post, conditional on like various things in the post, and then what it's outputting is well, it like depends on how it's implemented at different social media companies, but it's something like a prediction of the engagement score of the various posts, which the feeds then use to rank, your feed based on their personal prediction of how engaged you'll be with different posts. Those are very different kinds of systems. They're taking very different kinds of inputs. They're producing very different kinds of outputs. They have very different kinds of computation going on in the middle. And so, I think they're very different First Amendment objects, at least potentially. And then also, it's just like a totally different question from the First Amendment's perspective, how you write your law vis-a-vis each of those things. One thing I want to emphasize is my paper is about regulations of the outputs of the system itself, right? So a law that would be triggered when GPT-6, produces the genetic sequence to a novel flu virus, for example. And that might actually be quite a different First Amendment case than a law that was triggered when you, Kevin Frazier, or me, Peter Salib, copied that RNA sequence and posted it to my Twitter account, right? Yes, AI was involved. Like the reason I have it is the AI. But once I've adopted the speech and put it on my social media account, and the law forbids that as opposed to the production of the speech by the AI, that produces different First Amendment analyses. So in my paper, I'm thinking specifically about the intersection of LLMs, mostly generative AI systems, I say, but the LLMs are the ones that exist now that we should be most interested in, and laws regulating the outputs of the model themselves. So a law that would potentially forbid the say release of a model because the model produced the novel genetic sequence, but wouldn't necessarily forbid like Sam Altman from taking that RNA sequence and putting it on the OpenAI blog or something like that.
Right. So this is super helpful to get a sense of the very specific world in which we're engaging, because as you've pointed out, and as we will assign to you, dear listener, we've seen the Supreme Court start to grapple with the speech ramifications of, for example, those algorithmic recommendations that we see on Facebook, on Instagram, on you name the social media platform. Justice Barrett in her concurrence in Moody versus Net Choice raised a whole slew of just fascinating questions about whether the use of those recommendation algorithms is really expressive or if it's just a sort of mechanical analysis that's outputting whatever's going to foster that engagement, as you mentioned. So that's a whole different conversation that the Supreme Court has yet to figure out. But we're operating in this very specific world, generative AI, specifically LLMs, with an even greater focus just on the output of the AI, not necessarily whether the user has adopted that speech. So we've
Yes,
got those
great.
stakes. That's the
Yeah,
world we're
yeah,
living in.
and the thing I want to say about Moody is I think the Barrett concurrence, but the majority opinion also just really insist on this kind of specificity. Those were cases that sort of applied a prohibition on the sort of like on like politically based preferencing of content across all social media platforms. And what the majority opinion says, and I think the Barrett opinion puts, I think, even more clearly, is look, that's a lot of different machine learning models. That's a lot of different companies. That spans everything from like Twitter to Venmo potentially, as like covered platforms, with their software doing many different things with many different kinds of speech applications. So you can't just ask the question like, is this regulation of software? Are regulations of software regulations of speech? That's like almost a vacuous question. You really need to ask specifically what the law is doing and the kind of thing it's doing too. And the reason I think that this intersection of LLMs and regulations of the model outputs themselves is an important place to focus is for these kinds of reasons of sort of like large scale AI safety that I had gestured at before. So there are a bunch of people in computer science, including, like the Nobel Prize winning godfathers and Turing Prize winning godfathers of deep learning, who are really worried that in the coming years, like LLM style systems will become capable enough at these sort of quite dangerous tasks like synthetic biology, which you can use to make bioweapons, or cyber warfare, which you can use to take down entire power grids. That it's going to really, really matter that we regulate the models themselves such that upon release to the consumer, they are not able to just like arbitrarily output, code that will, disable your local metropolis's power grid. So I think that's why this is a really important intersection to focus on, and that's where the paper focuses.
And something that I want to double down on too, as we're talking in the middle of July in 2025, right after the AI moratorium fracas, I think is the only word that can describe everything that was associated with that. And what we saw there was a real great example and an unfortunate example of folks on the Hill, folks in DC, not writing with specificity and not writing with clarity and not grappling with the nuances of this technology. And so, with that in mind, I think a fun place for us to start into this inquiry of the different views of whether AI outputs do qualify as speech is to ask a fun question to kind of bring out some of the core technical questions we need to answer. So I'm going to start with Peter. What is the output going to be if we prompt a model to just say, "What's my favorite number?" And why does that matter?
What's my favorite number, or what's Claude's favorite number?
Well, so let's just we're prompting Claude, GPT, Gemini. Why does that matter? Because we don't know what's going to happen. Walk us through why that matters from a technical standpoint and this speech question.
Yeah. So the thing the paper's trying to get at is this question of, when an LLM produces some text, is that anybody's protected speech, right? It looks like speech. You ask a question in English and it produces a sentence in English, right? So wow, that looks even like a lot more like speech than the outputs of whatever Twitter's recommendation algorithm, which is spitting out some kind of just number, like some engagement prediction number. And so we say, wow, that really looks speech-like. And insofar as a law is like forbidding certain outputs, wow, doesn't that look like a law that's like directing or directly regulating speech in a way where if the speech is protected by the First Amendment, we're going to trigger one of these potentially very demanding tests. And so there, you asked me to talk about the theories that people have of why these things might be speech. And I totally forgot. This is a great classic law professor move. I answered half the question, got so excited about
Don't worry.
the first half.
I was going to drag you back eventually.
Great. And so I think understandably, because these things, these outputs of this specific kind of software is so speech-like, we have an intuition, like maybe it's somebody's protected speech. And I think there are basically four views that are represented in the law literature as to why the outputs might be somebody's protected speech. And And those are the views that the outputs might be the protected speech of like the AI company that made the model. So like if it's a chat GPT model, it would be OpenAI. The second view is that they might be the protected
Just
speech
to
of
double down on that, on the company value, to just probe that a little further, is the argument there that we see an AI company has gone through this whole training exercise. They've made very explicit decisions about the data they want included. They've refined weights. They've looked at what parameters to include. They've trained their employees a certain way. All of these factors adding up to certainly the company is attentive to what's going to come out of its model. Is that the sort of underpinning theory?
Yeah, I think that's right, and I think that that argument actually works best as a first order matter, as to not the company, but as to the maybe the employees as a first order matter. Like there's a bunch of people at OpenAI who are actually making those decisions, who are like deciding what training data goes in, who are like training the preference model in RLHF to decide what outputs are going to be like encouraged and which are going to be discouraged as like bad AI outputs. So that's another of the theories, that it's like the engineer's speech, the people who made the model. And then the corporate speech theory would be a sort of second order theory. It's like because it's the speech of some people who work at OpenAI, it might be OpenAI's corporate speech as well, which is a real thing, right? We often say that the New York Times has a First Amendment claim if a law prohibits something written by one of its opinion columnists, for example. So those are two theories: engineer speech, company speech. The third is user speech. I asked the model the question, and so maybe what's coming out is my expression in some way. And then the final theory is, well, like maybe we don't need to hang the protectedness on a person or a corporation. Maybe it could just be like the models, the AIs themselves have a kind of First Amendment interest. And so those are all the extant theories. And look, I think those theories are correct as to the outputs of some kinds of software. I think that's one of the reasons that like very smart people have these intuitions, have made these arguments. I just think they're not right as to like LLMs, as to sort of modern, generally intelligent AI systems, broadly construed. Okay, so
And
why is
to
that?
circle back on my question earlier about the prompt of what is my favorite number, how does
Yes.
that relate specifically to that third bucket of, oh, perhaps this is the user speech? Why do you think the answer or the infinite answers that could be generated there might cut against that being the user speech?
Yeah, so I think this is just like a general way of cutting what's going on when an LLM produces an output from what's going on when other kinds of software produce an output. So for many kinds of software, when I give that software an input, the output is like deterministically knowable ex ante by me, the person who coded the software. Like I could code a really simple piece of software where whenever it gets the input, what is my favorite number? It says 42, which, as we all know, is the answer to the universe, and everything. Um, and plausibly, that software, when it outputs 42, is like expressing my communication, right? Like it's like the best number bot that goes around the internet, and anytime it sees a tweet about like what the best number it is it posts 42. And like, why is it doing that? Well, it's because I, Peter Salib, think the best number is 42, and what I want to do is to make sure everyone else thinks that too. I've coded software that's carrying this idea from my mind out into the world, out to users. But it's really important for me to be successfully communicating that the software I'm using is the kind of software that reliably communicates like my idea, and not like some idea that I disagree with, and not some idea that I sort of like knew nothing about before, right? And so by contrast, when I ask an AI, when I ask an LLM, I ask GPT, 4.0, what the best number is, what's going on behind the scenes is like totally different. In many ways from what's going on with the simple 42 bot. I mean, look, it's still code. It's still computer code and still in that sense deterministic, although I think like cosmic rays can interfere with LLMs more than simple software just because of how complex they are. But fundamentally what's
You've
going
heard it
on is
here,
there's a
folks. This is now not only an AI law and policy podcast, but we have now added cosmology. So stay tuned. We'll get into black holes later.
yeah, I don't want to go. This is one hedge because I think there's one paper that actually suggests that even when all the parameters are turned down so that the LLM output is theoretically determinate instead of stochastic, that actually it's not because. But we can ignore that. I just want to acknowledge
I
that
love it.
this
I
literature
love it.
exists.
No, this is great.
Um, Okay, but what's going on inside an LLM is not some simple code where some human has mapped some determinate set of inputs to some determinate set of outputs, such that the human like knows what's going to happen. In some ways, it's just the opposite. Like an LLM starts out as an array of like many billions of parameters, many billions of numbers, all of which are fundamentally like wired to one another in layers. The layers activate depending on whether the prior set of inputs has given enough signal to those layers, and whether those signals or whether those prior layers produce signal is determined by the weights each parameter is given. The weights are initially totally random. It's billions of random numbers stacked up on top of each other. And then the model is trained to predict the next token over trillions and trillions and trillions of words of internet text. And every time it makes a bad guess, the weights are sort of quasi-randomly updated, and the model guesses again. And we just do that just a mind-boggling number of times until all those weights are sort of set up in a way that reliably predicts the next token. Okay, so like what's going to come out when I ask Claude what its favorite number is like, I don't know, right? I mean, I could ask it, I could set the temperature to 0, and then I could be pretty sure that going forward it would get me like a similar output. But it's just fundamentally not taking an idea that's in my mind and giving it to somebody in the world. Like it's not software that's designed to express a particular idea that someone had in mind. It's the opposite, actually. Like an LLM is a machine that can express everything, not something in particular. That's like the magic of LLMs. That's what makes them models of language and not models of some users' thoughts and ideas they want to share, and not the model of some engineer at OpenAI's thoughts and ideas they want to share.
So you posted this article first to SSRN in February of 2024. So you were writing this paper in the early days of this new wave of AI. So a lot has happened since 2023 and early 2024. One thing in particular may be the development of AI agents, and in particular, a greater increase in memory retention by these models, and an explicit goal from companies like OpenAI to retain as much information about a user and to apply that to future prompts with as much fidelity as possible. Do those advances change your analysis at all with respect to AI agents having a greater awareness, perhaps, of the user's preferences and memories? Does that change the equation at all?
Yeah, I don't think so. So I think the strongest argument for AI outputs as some person's protected speech, or some person's speech, right? Whether it's protected depends on whether that person has First Amendment rights, which, Americans mostly do, but like Belgians don't, as with many constitutional rights. But the strongest argument that the outputs of an LLM are somebody's expression, somebody's speech, is that there are ways to influence. Okay, so you start out with this model that can say everything. It can say all the stuff that I believe. It can say all the stuff I think is totally wrong. It can say all the stuff that I know. It can say all the stuff that I have never heard of before, right? And that's true not only as to me, but as to Sam Altman and all the people who work at OpenAI. And for that reason, they just don't meaningfully know what most of the stuff the model is going to say is. And a lot of it they would just reject. It's like not their ideas. It's not their communication. It's stuff they don't believe. But sometimes there's stuff you really don't want the AIs to say. And there are ways of influencing it not to do that. So I mentioned some of them earlier. You might not want the AIs to say really racist stuff. You might not want them to say like instructions for building chemical weapons. And even when I wrote the paper, we had techniques for sort of not preventing them from doing this, but from influencing them, right? In fact, like we don't know how to prevent them from doing this. This is an unsolved technical problem. We call this the alignment problem. But we have ways of influencing them not to do this. And the most fundamental way is, or the most widespread way is called reinforcement learning with human feedback, where basically, after you've trained them to predict the whole internet, you put them into a different training mode where you ask them questions, and if they give nice answers, you give them thumbs up. You say nice AI, good AI, and it reinforces those neural paths. And when they say bad stuff, you say bad AI, you give them thumbs down, and that nudges them away from the bad stuff. And I think the stuff you mentioned, the agent architecture, the memory, those are all, I think, in the same category. These are things that can influence the model, right? What GPT-4o says to you is it'd be somewhat different than me because it has an archive of memories for your preferences. Okay, what should we make of this? Like, what should this make us think about the outputs of the model? Should this update us to say, okay, well, this makes the outputs of GPT-4, I don't know, Kevin's expression, because it remembers what Kevin likes, or Sam Altman's expression, because it's now not saying like the really mean stuff Sam Altman taught it not to say. I think the answer is still just no. And if you want an intuition pump, just think about like your regular life, in which I'm sure you've encountered like children before. I have
Once or
a
twice.
5-year-old. Once or twice. You know children exist. I think probably most of the listeners know that children exist. They might even know that children, like AIs that have not yet been RLHF'd, go around all day saying stuff that their guardians don't want them to say. And all day, my kid is saying stuff, and when he says good stuff, I say, good kid, very nice, good things. I give him thumbs up. And then he says mean stuff, and I give him thumbs down. I say, no, don't say stuff like that. That's mean. And then like sometimes I succeed. Sometimes he's great. He gets nice. He's learning. He gets nicer over time, just like the models learn and get nicer on average over time. But then what do we want to say? Like because I succeed in changing my kids' sort of like normative preferences around what to say somewhat, then now suddenly everything he goes around and says is my expression? Like, probably not. You can ask him whether he likes tacos. We're in Mexico right now. He'll say, I hate tacos. I don't want to eat tacos. Disagree. Strong disagree. I think tacos are
Strong
great.
disagree. We're a pro taco family.
Yeah, there's a pro taco family and a pro taco podcast. And so I think that fundamentally what these agent scaffoldings, what these alignment techniques do is, okay, to some extent they change the underlying behavior or preferences or propensities of the model. But that doesn't change this fundamental fact that what you've built is the everything assayer machine, right? Just because you've taught the model not to be racist doesn't suddenly make it your expression when the model tells you that its favorite color is blue in a non-racist way. It's just like total non sequitur, right? It's like, okay, the model's behaving non-racistly and it likes blue. Does that mean I'm expressing that I like it? It just doesn't work, right? And it's not what we say in normal life either when we interact with other speakers who are learning and being influenced by us.
So we're still in the early days of generative AI, of LLMs, and of course of AI agents. It's, after all, only midway through the year of AI agents. So who knows what's coming next? We heard you earlier forecast the immediate arrival of ChatGPT 6. I'm just kidding. I know you were throwing that out there.
No, I have no inside information.
No, not yet. So when we're looking to the future of First Amendment law and AI, what are some of the questions that you're grappling with, that you're paying attention to? What are some of the big ideas you hope others will help you explore? without stealing your scholarship, of course. What's out there
No,
hanging
I
for
mean,
you
steal it.
to
You can
dive into?
cite it. That's what we do. Stealing with a footnote is
There we
perfectly
go. I
allowed. That's
say just
encouraged.
steal it. I'm a whole Brian Fry guy, but we'll save that for another
Fair enough.
podcast.
What should we be looking for? Yeah. So while I in the paper think is wrong to understand AI outputs as being the protected speech of anybody with First Amendment rights, that's largely an argument against treating regulations of these models, regulations of the model outputs, under these extremely demanding First Amendment tests, like strict scrutiny or like the Brandenburg test, these kinds of things. Now, what I do think in the paper is that there is a First Amendment dimension to AI regulation, even if it's not true that like what comes out of ChatGPT is my speech. It does relate to my speech, and in a bunch of ways that actually the First Amendment has some tools for dealing with. So one really valuable way in which AI systems contribute to the First Amendment is they help me learn things, right? They help me learn about the world or about politics or about science or whatever. And that way they're really valuable to me and to other protected speakers as we produce our own First Amendment protected speech. And in that sense, I think one good analogy of LLMs is to or LLM outputs is as speech, but as the speech of some entity that doesn't have First Amendment rights, right? So just because the LLM's outputs aren't my speech or Sam Altman's speech doesn't mean they're not speech, right? Like we started by noticing they're like extremely speech-like. And it turns out there are all kinds of speakers whose own speech doesn't get First Amendment protections. For example, Belgians. There's a case called Kleindienst versus Mandel, which is about a Belgian Marxist professor who wants to come to the U.S. and give a talk, and he gets excluded from immigration or excluded from a visa because he's said too many things about the Soviet Union, positive things about the Soviet Union. And there, the First Amendment, the Supreme Court holds that that speaker, the Belgian professor, doesn't have First Amendment rights. Like the Belgian outputs are not protected speech, like AI outputs aren't. But nonetheless, it's valuable for the academics in America who want to consume that speech to be able to consume it. And so the First Amendment dimension, but we don't think that laws regulating what Belgians can say are regulating protected speech directly. It's kind of an indirect regulation of the kind that I think we would ordinarily put into sort of an intermediate-ish scrutiny bucket. That's more or less what the court does in Kleindienst. And then there's other ways of using AI where I don't know. Maybe I do use it more like the 42 bot I mentioned before. Like you could run an LLM with some agent architecture that just took everything you posted on Twitter and then put it on all of your other socials, right? And that would be much more like a transmission of, your words to an audience. And so maybe uses like that, insofar as regulations interfere with them, should also get treated, like regulations of other tools for speaking. Tools like, the loudspeaker you might want to use to transmit your concert. And that's also an intermediate scrutiny case. So I think one thing that the paper tries to argue and that I hope will be accepted by courts and other academics is that insofar as lawmakers want to regulate the outputs of models directly, insofar as they want to write a law that says, look, if your frontier LLM in pre-release red teaming is sufficiently willing to produce the DNA sequence to a novel bioweapon, that a law that if it's like that, you can't release it until you do some more, safety engineering. That a law like that, on the one hand, is not a law regulating protected speech because the outputs are not protected speech, and thus isn't subject to, say, strict scrutiny or Brandenburg or whatever the relevant test would be. But it does have a First Amendment dimension. Like it does plausibly affect the academic biologists who might want to get those outputs for the purpose of studying like vaccines and mitigation, right? That's a First Amendment harm to them, and so it's not that lawmakers have carte blanche here. They're subject to First Amendment restrictions. They're just not the most demanding tests. And so that's something I hope like lawmakers are attentive to as they write these laws. That they do have some scope to do this, but that they are not given carte blanche. And then of course there's like a whole big range of laws that regulate closely related things to what my paper's about, for which I don't think we have the whole First Amendment analysis. Like I actually think even after Moody versus Net Choice, we don't really know how lawmakers are or are not allowed to regulate social media recommendation algorithms. But I hope that like the kind of framework of the paper that distinguishes between different kinds of models or doing different kinds of things, and then also different kinds of regulations that operate either on the model or on say the user or the reposter of the tweet, are going to get very different First Amendment treatment. So I think there's a lot of work to be done on a whole bunch of different laws, right? That I expect to be written in the near future about AIs that are not just limited to regulating the outputs of models themselves.
Whole lot of laws to write, a whole lot of research to do, and of course, a whole lot of tacos to eat. So, Peter, we'll let you get back to the tacos. Thank you so much for taking the time to join Scaling Laws.
Yeah, thank you so much for having me, Kevin. I enjoy it every time.